Hi, I'm Carl Conrad, the founder of Australian Immigration Law Services, and welcome to our YouTube channel. Now, many lobby groups approach the government to put their interests forward, paying thousands of dollars to join politicians for luncheons. Now, we can't afford that, so we feel it's about time we made a video to put a voice to all the temporary residents here in Australia. You may have seen the video we made pushing for permanent residency to be granted in the same fashion New Zealand and Canada did. Well, of course, the government did not rush out and do what we asked them to do, but it is important to let them know that there are issues to consider. It all adds up little by little. So it's time for our top 10 suggestions we hear from our temporary residents here in Australia. Now, everyone is entitled to their own opinion, of course, so we want to hear from our viewers to make their own suggestions in the comments section. My job will be then to post this video on every Labor politician's Facebook page until they write me nasty letters to stop. Then at least we know they've watched it. So let's go. Number 1, improve processing time. But of course we acknowledge the government is acting on this issue now, but boy, it could be going faster than it is. Number 2, protect the rights of Australian citizen children under the age of 18 by law, so their parents cannot be deported simply because they are unable to find alternative visas for them to remain here. A PR pathway should be developed without the need to resort to the contributing parent visa applications and its associated high costs and restricted eligibility. Number 3, the 186 Employer Nomination Scheme visa transition stream be open to all 482 and 457 visa holders. No more short-term and long-term lists, just one list for all. This has been talked about for some time now, but it's time to deliver. Number 4, allocate more places for skilled migration, the 189, 190 and 491 visas. At least temporary increase to give the opportunity for all those who were affected by the COVID pandemic and residing in Australia. There were too many who missed out on PR pathways. Please give them another chance by increasing the numbers. Number 5, the graduate stream of the 485 visa to be kept open to all vocational study as it is now. Currently, anyone who completes any trade certificate or diplomas to meet the Australian study requirement can obtain a 2-year 485 visa. This setting is meant to close on the 30th of June 2023. This should be continued permanently. Number 6, the graduate 485 visa should also be increased in duration, in line with industry associations calling for a 4-year working visa across all streams. Consideration should also be given to enlivening past 485 visa holders who were disadvantaged by the pandemic, not being able to have a chance to find suitable jobs. Number 7, the partner point system for the 189, 190 and 491 visas needs to be revised to eliminate the cruel practice of forcing applicants to remain single during long processing times. Initially, when these laws were introduced, it was stated that there was no undue harm to applicants because at times processing were about 3 months. Many applicants have to remain single for years now due to processing delays, simply because they would lose points by getting married or entering into a de facto relationship. This needs to change as of yesterday. Number 8, allow secondary applicants to be added to the 887 and 191 applications at any stage of the processing. Currently, they can only be included at the time of application. The long processing times experienced by 887's applicants recently has led to a inhumane outcome of partners being separated for years while the main applicant waits for their PR grant. It also means a significant cost of $8,000 for a partner visa application and then a further delay before the partner visa is processed. In addition, if an 887 visa has been granted, the offshore partner should be permitted a 3-month tourist visa without condition 8503 applied, so they can at least come to Australia and lodge the onshore 820 partner application. This would enable families to be united as soon as possible. Number 9, a permanent large-scale partner visa processing centre established in Australia that has the ability to finalise applications within a 3 to 6 month period. The days of 309 applications being unfairly penalised because they're from India, Pakistan, Bangladesh and more is a cruel practice. This is due to applications being processed in those countries without adequate resources. Other Western countries have a very quick processing time, such as one of our couples from the Netherlands who had their partner visa granted in just 1 month. The country applicants apply from should not dictate the speed of the processing. And finally, number 10, contributing parent visa processing delays are blowing out to unacceptable levels. It is now about 5 years of processing, and soon it will jump to 7 to 8 years. The cap needs to be raised on these visa grants to keep pace with demand. Applicants are paying a very large sum of money for these visas, so processing times should reflect this. Now, you will notice that these suggestions are not far-fetched left-wing ideas from crazed drug-induced media trolls. These are realistic, fair-minded requests based upon thousands of our viewers' comments and our thousands of consultations we have here in our office. They are all achievable without too much fuss, and the Australian public wouldn't even notice they have happened, which is probably better anyway, for they have no idea about immigration law. So parliamentarians, just think about it. Take a read of the comments from real-life temporary residents here in Australia, and don't just take my word for things. Thanks all of you for watching, and as always, take care out there, and I'll see you next time. So bye for now. Oh, and don't miss our weekly Sunday night news roundup either.